How to file a UCC-1 and reclaim control over your strawman. Legal definition of the strawman entity. Pursuant to 15 U.S.C. Section 44, a corporation includes any trust or association, whether incorporated or not, established to conduct business for profit. The name presented in all capital letters, typically derived from one's birth certificate, is legally treated as an unincorporated corporation. As a state-created entity, it falls within the exclusive jurisdiction of the government unless a rebuttable claim is made asserting private control. 2. Establishing secured interest through UCC filings. The filing of a UCC-1 financing statement and associated security agreement serves as public notice that the real, living individual, secured party, has a legal claim over the artificial entity, debtor. This separates the legal fiction from the living being, repositioning the entity as foreign to state jurisdiction. The filing does not require the existence of a written agreement if a verbal or implied contract exists. 3. Practical implications of UCC filings. States may challenge the UCC-1 filing on the basis that it constitutes a self-contract. This challenge is rebutted by evidencing the distinction between the living being and the strawman corporation. Registering a trade name further evidences the commercial separation. The subsequent recognition by corporate entities confirms its treatment as a legally distinct, profit-oriented enterprise. 4. Treasury accounting and the strawman's individual master file. The Internal Revenue Service maintains an individual master file, IMF, for each strawman, cataloging commercial and legal activity. Charges, many of which are fictitious or based on foreign criminal presumptions, are monetized via Treasury bonds and contribute to the national debt. These charges are levied against the strawman, not the living individual. 5. You are the creditor. Contrary to popular belief, the living man or woman is the original creditor to the strawman. It is through the birth registration process and subsequent commercial acts that credit is extended to the federal system. Institutions such as the Federal Reserve or IMF act in a custodial, not proprietary, capacity, benefiting from the interest generated by instruments originated by the people. 6. Balancing accounts through acceptance for value. The method of acceptance for value enables the secured party to discharge liabilities recorded against the strawman's account. The process involves offsetting public debts through private credit issuance. As outlined by Representative James Traficant in the Congressional Record, March 1, 1993, Volume 33, H. 1303, the United States has operated in Chapter 11 bankruptcy since 1933 under emergency war powers. 7. Federal bankruptcy and H.J.R. 192. House Joint Resolution 192 of 1933 abolished the gold standard and eliminated legal enforceability of gold clauses in contracts. The resolution allowed the discharge of debts via legal tender, i.e., fiat currency, establishing a statutory remedy that precludes criminal liability for officers and offers remedy to those who know how to access it. 8. The Federal Reserve System and hypothecation. The Federal Reserve operates independently of the federal government under principles of admiralty/maritime law. It functions as a maritime lender and hypothecates property, including labor, as collateral. U.S. citizens, as legal beneficiaries of the system, unknowingly pledge their assets and labor through birth certificate registration. 9. Legal title, equitable ownership, and trust structure. By registering with the state, legal title transfers to the government, but equitable title remains with the individual. The property, labor, and assets of citizens serve as collateral in a trust structure administered by the Federal Reserve and its international banking partners. This arrangement mirrors a feudal model wherein citizens are tenants of their own property. 10. Discharge versus payment. A critical legal distinction exists between paying and discharging a debt. Federal Reserve notes, FRNs, lacking intrinsic value, cannot lawfully extinguish debt but only discharge it. True payment requires substance, gold, silver, or lawful consideration. Hence, debt remains perpetually in circulation, ensuring continuous subordination of the people. 11. The Federal Reserve as a sovereign entity. Established in 1913, the Federal Reserve is not a government institution but a privately owned consortium operating through a joint stock trust structure. This structure, modeled after canon law trusts, grants the Fed sovereign-like powers over monetary policy, despite being explicitly prohibited by the Constitution from issuing currency. 12. Legal remedies available to the people. Through the filing of UCC-1 financing statements, security agreements, and related instruments, individuals may lawfully assert their status as secured parties. Additional procedures include reserving non-cash routing numbers, issuing bills of exchange, and directing discharge instruments through the Federal Reserve for proper credit application. 13. Recovering equitable interest. The secured party may reclaim interest from constructive trust profits resulting from registered property and labor. If the government has invested titles without compensating the equitable owner, the remedy lies in commercial redemption and lawful notice. Failure to act implies acquiescence and forfeits rights by presumption. 14. Quid pro quo and legal standing. Proper routing of discharge instruments through the Federal Reserve validates quid pro quo exchange and aligns with their bookkeeping system. By asserting legal standing, commercial identity, and public registration, individuals convert themselves from presumed debtors into recognized creditors within the commercial matrix.